All right. Good morning, everyone. It's October 7th, and this is our Law and Policy Committee meeting. Good morning, Commissioner Cardenas. How are you doing this morning?
I'm doing well, Mr. Chair. How are you?
I'm doing well as well. All right, let's go ahead and get started with Ms. Linker, if you could call the roll first, please.
Commissioner Cardenas?
Here.
Chair Matich?
Here. All right, at this point, we'll move to item number 1. This is public comment for items not on today's agenda. Do we have any public comment on the telephone for items not on today's agenda? Hearing none, and I see no digital public comment. We'll move to item number 2, approval of the September 9th, 2020 L&P committee meeting minutes. Commissioner Cardenas, did you have any edits or comments on the meeting minutes?
I do not, Mr. Chair. I'm prepared to move.
Excellent. Do we have any public comment on item 2? Hearing and seeing none. Commissioner Cardenas, you have a motion?
I move to approve.
All right, I second. Ms. Linker?
Commissioner Cardenas?
Yes.
Chair Matich?
Aye.
The motion passes.
Thank you. All right, we'll now proceed to item number 3. This is our interested person feedback on pre-noticed amendments to the regulations governing enforcement process. And this morning we have our General Counsel, Mr. Bainbridge, here to present this item. Good morning.
Good morning. This is the third time these regulations have been to Law and Policy Committee, so I won't go through, I won't do a thorough presentation here. What I was planning on doing is going through the changes that have been made since the Law and Policy Committee last heard this, to our proposed changes, mostly reflecting comments made at the last hearing, and then if there's any questions regarding any of it, that would be fair game. So I think there were just basically 2 changes that were made. We'll start with 18361.1, and you see the highlighted language there. That shows where there was a change made. And what we've done is eliminated the use of the term privilege log. It's kind of a term of art, so we didn't want to have any of the meaning that went along with that. We revised it to just say when you're withholding records in response to an administrative subpoena, they should provide a description of what those records are. So in point 1, this one is dealing with the situation where a respondent receives an administrative subpoena from the commission. We've made a similar change to the provision in 18361.4, which concerns the production of records during the probable cause proceedings. Again, and let's see, where is this? I'll find the exact place. It's page 5, lines 5 and 6. You'll see the highlighted language. Again, we've removed reference to a privilege log. There was some questions of whether the Enforcement Division in saying what documents had been withheld would only identify those that were privileged and not withheld for other reasons laid out in the regulation. So we've removed the reference to privilege to make it clear what we're talking about is a description of any records that are not produced in response to a request by the respondent in a probable cause proceeding. So that's kind of one change. It's just been made to both documents provided by the respondent or other witness and documents provided by the Enforcement Division. And then the other change we made since last time was on page 7 of 18361.4. You see it at line 17, the highlighted language. This concerns the provision that we've proposed adding where a hearing officer can receive evidence after a probable cause conference. The intent behind this was the hearing officers were seeing instances where a respondent, typically an unrepresented respondent, would come to a probable cause hearing and they would say, well, I have an email that says this, or I have this record, or I have that record. But they didn't have the record with them at the time, and they would ask if they could send the hearing officer that record later on. And the hearing officers didn't have any guidance on what they could do with that. They typically, I think, would allow the respondent to provide that record after the fact. There had been some questions as we originally drafted this as to whether this would allow enforcement staff to then provide evidence after the PC hearing, which was obviously not the intent. The intent was really to address the situation where the unrepresented respondent has additional records or claims to have additional records that they didn't bring with them to the probable cause conference. So the language we've added, we hope addresses that concern because it requires that it be something mentioned at the probable cause conference. So if they say, I have this email that says this, if they mention that at the hearing, they then could provide the record as a follow-up to the hearing officer, essentially to confirm what the party had claimed at the probable cause conference. So that's the background and the reason for that change. Other than that, we haven't made any significant substantive changes since this was last heard in Law and Policy last month.
On that last point, Mr. Bainbridge, I have two questions. First, under our existing process, doesn't the hearing officer currently have the ability to allow for additional information to be submitted after the probable cause hearing?
Well, it doesn't say that in the regulation, under the current regulation. Yeah. My understanding is that's typically been the process that's been followed by the hearing officers. As far as I know, this has only come up in the context of a respondent wanting to add additional information. Yeah. And hearing officers are usually very open, especially with pro pers, to taking in whatever they have, even if it's after the fact of the hearing.
Yeah. I mean, part of the reason I asked is because on page 7, there's language that appears to be struck saying, if the hearing officer requires additional information before determining whether there is probable cause, he or she may, and there's nothing after that. And so.
Yeah, and so what we've added is or after. So before it was they may permit any party to submit additional evidence at the probable cause conference. Got it.
Okay. And secondly, as proposed by staff here, this isn't a circumstance where anybody has an entitlement or a right after probable cause to start submitting whatever they want in an unrebutted fashion. This is, at least as I read it, more structured, where the hearing officer would first have to make a finding of good cause to allow additional information. Secondly, the only time that would be permitted is to verify or confirm a statement made at the probable cause hearing. So there's two sort of parameters on that submission. Is that accurate?
Yeah, that's right. And that's the sentence we added, I think we assumed when we had the good cause provision in there, but I think adding the sentence helps to really clarify that point, that this should be something that is brought up at the probable cause conference itself. So it wouldn't be new information. It would.
And that's really to my point. This would not lead to a circumstance, as some folks I think have expressed concerns about, where for the first time they're hearing something on a submission after probable cause. Instead, this would simply be a follow-up following probable cause that is tied directly to a statement or an assertion that was already made and the party had prior knowledge of. Right, and I think it's important to remember that the enforcement division is required. What is required for a probable cause conference is a summary of the facts that support the allegations. So if there were a fact that wasn't included in the probable cause report prepared by the enforcement division, if it wasn't at least alleged in there, it wouldn't be something you'd even consider. So it wouldn't be a chance to submit new evidence. It would be a chance to submit something to support evidence that has already been discussed at the probable cause hearing. Got it. All right. Thank you. Commissioner Cardenas, did you have questions or comments on the changes to these proposed regs?
Mr. Chair, I think I've got one that with respect to 18361.4, what we just mentioned at the end of subsection, I guess new subsection F, the new language, quote, only evidence that verifies or confirms the statement made at the probable conference may be submitted after the conference. I take it that also includes post-conference evidence that would purport to negate or dispute a statement made at the probable cause conference. Couldn't it be the case that something comes up in the conference and a party takes a disputing position but doesn't have at the moment evidence to substantiate?
Mr. Bainbridge?
Yeah, that's exactly right. That's typically the scenario where it happens, where they say, no, that's not true. I have a record that shows that's not true. I think under this, what the hearing officer would do is ask whoever was saying, I have a record that I don't have with me, ask them to describe the nature of the record, and then they could provide that record subsequent to the hearing to show what the record was.
Okay,
Well,
so then the post-conference evidence would be that which would verify or confirm a party's contention that something proposed or suggested by the other side was not correct. So we can read it that way. Is that what you're saying?
Yes.
Okay. Thank you.
Well, can I ask I actually think that's a good point, Commissioner Cardenas. I mean, just in terms of wordsmithing this, because when you asked that question and I reread the sentence, I think if you just read the sentence very literally, it does seem to suggest that the only evidence after the fact has to confirm or verify a statement that was made. So if somebody said something at probable cause and I was on the other side and I thought, that's not true, I have a document that shows that that's not true. Strictly speaking, this statement, I don't think would allow me to submit that evidence unless at the probable cause I said out loud, that's not true. I have a document that says that that's not true. And only under those circumstances, because then I'd be verifying my own statement. And so I wonder if we could add some language here that makes it clear to verify, confirm, or perhaps negate a statement that was made at probable cause, to make it clear that it works both ways, unless I'm missing something.
Okay. I understand the point. I was thinking of it you're confirming your denial, I guess, but you're saying in the situation where you don't deny it and then realize after the fact that there's evidence, we would want to allow that to be submitted to the hearing officer as well?
I would think so, unless there's a reason that wouldn't be a good policy.
My only thought was this, as written, whatever the fact is as stated by one of the parties has to be stated for the record. So if it's going to be a denial, they can say, that's not true, I have this email, and then they could provide the email. If they don't say anything and just provide the email after the fact isn't discussed at the hearing itself. So then there's no chance for someone to say, wait, but that's not true, I have this other email. So I was envisioning it as it was something they would have to, if they're objecting to what someone's saying, they would have to say it out loud at the hearing in order to, and I think they should have to identify what the record is that they're going to be providing.
Yeah. What do you think, Commissioner Cardenas?
Yeah, I think that makes sense. Yes.
Right. So, Mr. Bainbridge, I think you can maybe wordsmith that a little bit for us.
Okay, so to add confirms or disproves a statement?
Correct.
Okay.
Yeah, I think that'd be helpful. All right. Commissioner Cardenas, did you have any additional questions or comments on the proposed regs?
Well, I'd like to know if Mr. Bainbridge believes that there's anything contained within the comment letter from the California Political Attorneys Association that warrants some kind of a response.
That's a broad question.
Yeah.
Yeah, I'm going to pull up the letter. I would just say in generally, I think the claims of people being denied due process doesn't really make sense in this context. The due process that is owed is what is contained in the statute in 83115, which is, and I can read the actual statute, it's much less than what we have contemplated here in terms of what the respondent gets prior to PC and what their role is in a probable cause hearing. The statute contemplates basically a determination by a neutral hearing officer with the agency of whether there's sufficient evidence to justify initiating an administrative hearing. So I would say anything on top of what is required by the statute, which is, let's see, a person alleged to have violated this title shall be notified of the violation by service of process registered mail, provided with a summary of the evidence and informed of his right to be present in person and represented by counsel at any proceeding of the commission held for the purpose of probable cause. So the two rights they have under the statute is to receive a summary of the evidence and to appear in person and be represented by counsel at the proceeding. So that's the process that's anticipated. This is above and beyond what happens with a lot of administrative hearings where a decision whether to bring an administrative action is made at the department level without any input from the person who's going to be charged with an accusation in an administrative proceeding. So I think what the statute contemplates is a pretty limited hearing. We have expanded that to allow for certain discovery of records. It's only been in the last 9 years or so that the commission has even allowed for that. So I think to claim that people are being denied due process in any way under this is a little disingenuous considering what the statute provides for in this stage of the proceeding. All the things that they've requested in terms of due process do happen later on in the proceeding when you get to an actual administrative hearing. So I think that's the appropriate time for a lot of these. If that never happened, I would agree with a lot of what they have to say, but after a PC hearing, if PC is found, then all of those protections and more go into place, and there's a mechanism to deal with some of these disputes or disagreements that the statute doesn't contemplate and that just we are not equipped to do as hearing officers because we don't have any authority other than to decide if the probable cause standard is met under the statute.
Mr. Bainbridge, what about the contention made at beginning at the bottom of, I believe it's the second page, continuing to the top of the third page of the CPAA letter regarding the scope of the quote publicly available records exception? To the way I read CPAA's contention is that a respondent could be in a position where she is told that among the things being purportedly appropriately withheld are certain items which in any event are in the public domain anyways, and it's her job to go out there and find it. But if it's, I mean, if it's subject to the Public Records Act, I suppose, but CPAA suggests the possibility that this could, at least theoretically, include any iota or scintilla of evidence that may exist somewhere in the broader hinterlands of the internet. Now, I don't know how specifically this might arise, but it occurs to me that that if the enforcing arm of the state has information against my interest in its possession, for it to tell me, well, if you spend enough time on the internet, you might be able to find it. I'm not sure that strikes me as a system which is equitable to me. Yeah,
I think, and that is a theoretical, as you said, point that CPAA has brought up. The intent of this, and this was added after we had discussions with the Federal Elections Commission, and they have a very similar rule at what they call their probable cause. It's a little different than our probable cause hearings, but similar enough. And it's aimed at items like Form 700s and campaign statements and documents that, you know, in certain instances may not actually be in the file of the FPPC because they pulled them up online and looked at them on SOS's website. So they don't want to then be responsible for records maybe they've looked at, but they don't necessarily have saved on their hard drive. I think we could look at this language and maybe make it more clear that those are the type of records we're talking about, and not just some theoretical, if you search the dark web, you could find this document somewhere. That's not the intent to say, go find these records yourself. It's more the intent that records that are publicly available, it's not then on the onus of the enforcement staff to have to go find all of these records on behalf of counsel for the respondent. But I can see their point, and I think there's probably a way we can look at this language to make it clear that we're really talking about records that are readily available, not records that are theoretically available.
Right, and Mr. Bainbridge, I appreciate your point about staff's current intent, but there's as you know, there's a great difference between divining legislative intent when you're dealing with codified law, and there's online varying degrees of indications of various levels of sufficiency of the legislature's intent when arriving at this legislative determination. You can see the arguments, you can see the votes, you can see the points, you can see the points that were made. But in this type of administrative procedure, it's how would one know that in October of 2020, Chief Counsel to the FPPC suggested in a Zoom committee hearing that the intent was X, and at some point in the future, staff's intent happens to be Y. That's really my point. Thank you.
Yeah, I think, if I may, I think, again, I would just emphasize that the addition of this provision tracks what the FEC does, and I think based on our staff's communications with them, this doesn't seem to present any particular challenge at the FEC level, and no one in the regulated community suggested otherwise. Secondly, from my own personal experience prior to this appointment in litigation, we're really talking about a semi-discovery process here, and in discovery, you certainly don't turn over publicly available documents that are in the possession of the other party. And part of that is because it's duplicative, and we want to make this efficient. I do think that Commissioner Cardenas is right, though, to the extent that CPA's concerns to me on this provision seem to be animated by timing. So they're worried that even if a document is in theory publicly available, they may not get it within the time frame that they need it to adequately respond. Although I suppose that would be good cause for the hearing officer to extend the time frame, and that is available under the regs. So there's already, frankly, an outlet there if that's the concern. But I do think I think we should work on this language and clarify that it's only readily available or immediately available publicly accessible documents. I think that would be helpful and come closer to addressing Commissioner Cardenas and the CPA concerns here.
Yeah, and now that I'm thinking about it, we had copied the term used by the FEC, but probably describing them as public records instead of publicly available gets to the point, at least of the record somewhere available on the internet. I think public records has a sort of at least a definition of some sort, or is known what is considered a public record. So that might also help by just flipping the words around a little bit.
All right. What do you think, Commissioner Cardenas? If we clarify that it's readily available, immediately available, does that get to the concern that you're expressing?
I think that would be very helpful. Yes. Thank you.
Good. Mr. Bainbridge, either you or Executive Director / Chief of Enforcement West, can one of you talk to us a little bit about the assertion that we're eliminating respondents' ability to appeal discovery objections? The way it's being presented to us seems like that's something that happens a lot. Is that true? Is it not true? What's your perspective on that?
Hello, Galena West. Am I supposed to put camera on? Start video. I'm very savvy. Watch out. Okay. So since the discovery has been added to the regulations 9 years ago, and my recollection, there's only been one dispute, and that was very difficult for the hearing officer since there is no real mechanism for them to solve the dispute. But other than that, we've had the last 4 hearings, administrative hearings we've done, have all been unrepresented. and there's been no discovery disputes, and there's never been any issues. And so to paint it as a prevalent problem would be not correct. So the facts are the majority of these issues, and when reading the CPAA letter, it talks about how this is for pro-PERS, but pro-PERS haven't had any issues in the past couple of years representing themselves and going all the way to administrative hearing. As I said, the last 4 administrative hearings have all been representing themselves. And so I think that to frame this as an issue that needs to be resolved is more not exactly correct. I think the correct term is that this is a one-off that has become us searching to solve something at a very low stage and give the hearing officer a lot of different powers and responsibilities that are already in the APA. And we're talking about when the administrative process begins, but we're not talking about when the administrative hearing begins. So once we issue an accusation, the APA kicks in, and that's when all of the protections and all of the procedures and all of the due process rights are already written in. And the Act has also been, the regulations in the Act have also been reflected of everything that's in the APA. So we're talking about 2 different stages, and we're not really talking about a big issue that we're trying to solve here.
And I would just add that to answer the first question, no, there's nothing in the current regulation that deals with a discovery dispute. We've had one that we know of over the last 9 years. But that provision was just intended to clarify for the hearing officer, because the hearing officers weren't sure what they had the authority to do. So that it's addressing a one-time issue at this point.
And in that one time in the last decade where there was dispute that rose to the level where it was presented to the hearing officer, were the respondents pro per, or were they represented by counsel?
They were represented by counsel, in fact, counsel that wrote the regulation.
And the effect of that type of dispute, I would imagine, is to delay the process.
The process was very, very delayed, especially since the hearing officer was unclear as to what their role was, and they really did not want to be the decider of discovery, because if you look at the hearing officers for the FPPC, it's not like an APA hearing officer where they go through training and they shadow and they find out how to resolve these disputes. So it's really putting them into a very difficult position.
And I mean, for my mind, at least, I mean, part of the impetus for taking a look at you are subject to the full panoply of due process under the Administrative Procedures Act, where a trained administrative law judge can adjudicate using standards, actual standards, a discovery dispute. So, I mean, to me, it seems reasonable to take this approach. But Commissioner Cardenas, what do you think?
I think I agree with everything you said, Mr. Chair. Again, as a non-litigator, this is beyond my bailiwick. I'm just trying to understand, from an equity position on both sides. But I think what you've stated sounds fair.
All right.
Also, Mr. Chair, if I might.
Yes, please.
I'm sorry to say that for a considerable portion of your last stated comments, I'm afraid, at least on my end, I could not hear anything.
Okay. Well,
which is probably why it made sense.
Well, let's start with, can you hear me now?
Yes, and you're making sense.
All right, good. Well, I'll try to keep that part up. So what I was saying is, I think big picture, part of our goal here is in response to feedback from the regulated community to make our process here more efficient from a time standpoint, because we continue to hear how it takes so long to get through the process with our cases. And so what staff has done after the benefit of, a decade's worth of experience under the existing regs, they've identified points where we could make the process more efficient. And that is the impetus for their ideas. Are you still with me, Commissioner Cardenas?
Oh, yes. So my
Okay,
intuition
good.
was correct. That makes total sense.
Okay, good. And I just think that, and following probable cause, everybody is subject to the full measure of due process under the Administrative Procedures Act. So to the extent that there are lingering discovery disputes, there is a mechanism where an administrative law judge who's trained in adjudicating those types of disputes and will be doing that subject to clearly articulated standards is in the best position to adjudicate it at that time. So it's in a lot of ways it's unnecessary that we have a pre-appeal of a discovery dispute before you get to a trained ALJ. That's my point.
Yes, I understand that.
All right, well, very good then. Do you have any other questions or comments on the regs before we open it up to public comment?
No, Mr. Chair, thank you. I did not. I just wanted to point out perhaps someone can get in touch with Ms. Abduli of the CPAA in the midst of making what may have been, for at least for her part, a very important argument. There's a sentence that just gets cut off right after the word "however." So yeah. She could have been about to say the key to the universe is, but then there's nothing there. This is near the bottom of page 2. It could be a typo, but there also could have been something substantive that was going to follow. I don't know.
All right, that's a good point. Hopefully she'll provide some public comment and maybe illuminate that for us. All right, so at this point then, I think we're ready to turn to public comment. Before we do though, consistent with our own internal procedures, I did want to disclose that I did have a conversation with Emily Andrews from the Olson Remshow firm. She's a partner there. She's also part of the CPAA task force about these regs at an earlier stage. And so I just wanted to make that disclosure publicly. So at this point, let's go ahead and open it up on the phone line for public comment. Do we have anybody on the line who wishes to comment on item number 3? Going once, going twice.
Hi, sorry. Can you hear me?
Yes.
Hi, this is Allison Leary with the League of California Cities, and I am just wondering whether we had submitted a letter to you on these regulations on September 23rd. Did you not receive that letter?
We did receive your letter. Your letter was identified as in response to item 20 on our commission meeting agenda, which is scheduled for later this month. I did note that it was substantively, if not identical, very similar to the letter we received from CPAA. But please feel free, the floor is yours if you want to make additional comments.
Oh, no, I just wanted to make sure that you received our letter. Thank you.
Yes, thank you. Do we have any additional public comment on item number 3? All right, hearing and seeing none. Either Mr. Bainbridge or Ms. West, did you have additional comments for Commissioner Cardenas and I? All right, well, these regs are up for adoption, as I just mentioned, at the October commission meeting. Our normal policy is to provide a recommendation if we feel like we're in that position. Commissioner Cardenas, my view is that we should recommend adoption of these regulations with the additional edits that we've discussed today. What do you think?
Yes, I concur, Mr. Chair.
All right. Well, so we have a motion to recommend with the amendments discussed today. Do you care to second that, Commissioner Cardenas?
I second that.
All right, Ms. Linker?
Commissioner Cardenas?
Yes.
Chair Matich?
Yes.
The motion passes.
Excellent. Well, we will present that recommendation next week. Moving to item number 4, We have interested person feedback on pre-noticed amendments to regulations governing the Enforcement Division's Streamline and Warning Letter programs, and a new Tier 2 Streamline program. And we have Executive Director / Enforcement Chief West here.
Yes, good to be a slash. Better when it's not a slash.
Pulling double duty.
Thank you. So this was presented a couple of commission meetings ago, and what I have found is that it's a lot of material. So I did a PowerPoint presentation and tried to get as much information out, and haven't received very much public comment. So what I've done instead is presented the Law and Policy Committee with a policy bullet point memo that hopefully we can discuss where you guys are at on the certain proposals and ideas that are in the Streamline Tier 2, Tier 1 warning letter proposals that are very, very long. So hopefully the 2 pages is much easier to have a discussion about. So without further ado, we can get into the memo, which basically has 4 questions. And the first question is about the criteria for major donor committees and behested payment reporting. And the second one is about the populations for jurisdictions, which currently exclude a lot of committees based on the population standards. And then the third one, should the commission invest resources to add an educational diversion program for options for enforcement in the future? And the fourth one is, should the commission add more discretion to the Streamline and Warning Letter program? So those are the basic topics, and I can go through the memo if that's how you guys would like to do the discussion.
Can I ask a clarifying question on
Sure.
number 1?
Mm-hmm.
Under number 1, the question presented is, what should the criteria be for major donor committees and behested payments reporting? My understanding is that major donor committees and behested payment reporting are not currently subject to the Streamline. So what we're talking about here is adding these 2 types of violations and making them eligible for Streamline. And then what follows all the bullet points are the manner in which we've accomplished that. Is that accurate? Exactly.
So what came out of the commission meeting was the commissioners generally said that they had a consensus about adding the 2 new categories. And so now the discussion turns to what kind of criteria are we looking for to add these categories to the Streamline program.
Okay, great. I just wanted to clarify that in case.
Thank you. Yeah, that was.
I've been following our meeting a couple meetings ago.
That was a while ago, sorry.
Yeah. All right. No, I say go for it.
Do you want to go for it? Okay, here we go. So we're going to talk about major donor committees first. And so the proposal for major donor committees is that Tier 1 would apply, which is our lowest tier, which is what our existing program is, if the contributions for the calendar year were less than $50,000, and then they would be excluded if the contributions also required a 24-hour report within the last 16 days. The 16 days, as you'll remember, is when there's no reporting because the pre-election is from the 17th day. So that last 16 days is considered critical for reporting. And the recipient also did not file that 24-hour report. So those 2 would get you out of the first tier. So the first tier would be the lowest amount of penalties. And so if it's over $50,000 for the year, or it's within that last 16 days before the election and there's no 24-hour disclosure, those would be excluded.
Okay.
So then those could push you into Tier 2. So the Tier 2 limit goes up to $150,000 and less than 3 statements or reports were late. So the reason that we put that in is because major donors only file twice a year plus their 24-hour reports. And so if you're doing more than 3 statements, you have a lot of activity. And so we're not really interested in having someone with a ton of activity being eligible for Streamline. We would like to exclude that type of behavior. And then also, we're keeping in the no disclosure within the last 16 days. Because obviously, if there's no disclosure within the last 16 days, the commission has found that to be very severe and to cause you to have either some intent, or even if you don't have intent, the disclosure to the voters is very important. Okay. Anybody have comments on major donor committee eligibility requirements?
Do you have any sense of, if you implemented this proposal, what would the effect be on the current workload for mainline cases with respect to major donor violations?
So what we have found is that major donor violations are sometimes excluded almost automatically by the 24-hour reporting rules, because generally, if you didn't know of your obligation to file and you did the contribution within the last 90 days before the election, then you're going to run into problems under the current Streamline program. And then also the amounts, major donor amounts obviously are higher, because that's what makes you a major donor. And so those can find themselves excluded from the current Streamline program quite a bit, which is why we're making this proposal. So I do think it would have an impact, taking some cases out of mainline that would have qualified as major donor cases under our old program. Because our old program, as it first started in 1999 and then later, had a category for major donors, and then we just thought we were smarter than that, and we would put them all together, and then we found out, oh, there was a reason that they had their own category. So we learned from our mistake, and that's why we're making this proposal.
Okay. So this would reduce workload on mainline?
Correct. Both of these would.
Substantial fashion.
Substantially.
Okay. All right. Commissioner Cardenas, questions on the major donor piece?
No, Mr. Chair, I don't at this moment. But hearing the expected, if approved, diminution of mainline workload, I'm wondering, Ms. West, how that then might relate to our interest in adding resources to an education effort that you discuss in the second page of your bullet point memo. An education diversion program for I guess first timers or less experienced filers, if you will.
Right, I'm glad you bring that up. So when we talk about number 3, which we can do right now, is the point of number 3 is that it's going to take some resources to get an education program up to speed to where there's some sort of compliance, there's some sort of registration and certificate that can be shown to enforcement. And so the goal would be to get this kind of up and running, and then at that time revisit the Streamline regulations to see what the commission would want to take out of Streamline or warning letters and put into diversion. So it would be kind of a 2-step process. Right now, we're dealing with the now, which is what the Tier 2 does. And then as we'd have to put significant resources towards this diversion program, once we got that to a point where it was ready to go, we would need to be looking at the regs to see what would qualify for the diversion program, or we would do a policy memo of the commission saying that everything that qualifies for Tier 1, if it also meets this criteria, could possibly qualify for the diversion program. So we'd have a couple different options on how to approach it once we get to that point.
Thank you.
All right. Why don't you go ahead and move on to behested payment reporting then?
Okay. So as everybody knows, behested payment reporting cases are on the rise, and we have a significant workload that is stagnant at this time. And the reason that is stagnant is because it doesn't really fit into the current Streamline process, because behested payment amounts start at $5,000, and they can, gather very quickly into larger amounts. And so since that's the case, we really wanted to get commission guidance as to what's a warning letter for a behested payment report and what is a Streamline penalty, what is a mainline penalty. And so what we've tried to do is listen to all of the discussions that have been going on about behested payment reporting with the commission, and remember what is important and what the commission has singled out as the things that are the most frustrating about these types of payments. And so what we've done is excluding when there's the maker of the payment is the subject of, sorry, hold on. the subject of the government decision before the behester's agency or the behester themselves. The amount was $50,000 or more for a single behesta payment, and the amount required to be reported when divided by the number of public officials was more than 50,000, and the behester has a prior penalty. So that's the exclusions from Tier 1, and then we just bump the amount up to $150,000 for Tier 2, and we also include if the member is a named party. So what we don't include, and what is not written in here but is written in the regs, is that if there's a personal benefit. So that would be automatically excluded from, or even a perceived personal benefit, I think is what the language is right now, then those would be automatically excluded from the proposed new streamlined two-tier process, because that's what the commission has pointed out as their biggest concern about behesta payments. Those would all still be mainline cases. This would be to deal with just late payments or behesta payment reports, and to deal with the issue of when multiple public officials are on the same behest and dividing it instead of attributing that amount to them to where they're excluded from most of the programs. Let me know if that made sense or if I was a little circular there.
No, I think that made sense.
Oh, that's good.
All right. Did you have anything further in your presentation just on behested payment reporting?
I did not.
All right. Commissioner Cardenas, did you have any questions? I have a couple questions, but I want to see if you have some first.
I believe I have one, Mr. Chair. Ms. West, when you refer to the maker of the payment, that includes say that the payment is made by an organization and not an individual. Would this include both the individual who may be driving the payment by the organization?
That's an interesting question. I hadn't anticipated that when I wrote it, but I can definitely make it more inclusive to where it's also the responsible person for the contribution. We'd have to look into that. As of right now, it's just a generic term of maker, so it could be defined.
Yeah, it really gets to the crux of the issue. What is the identity of the actual decision maker, the player, right?
Mm-hmm. And so that exclusion would count for the decision maker as well as the entity, is what you're proposing?
Right now, I'm just proposing clarity, but
Sure.
I think that would be my position.
Okay, I'll look into that.
So I had a question kind of along the same vein. I mean, when I see where you're going with excluding, with this exclusion, the concern I have at this stage, this early stage, is a big concern about, or the subject of a governmental decision, right? Like, so the person making the payment is subject to a governmental decision by the official who made the initial request for support, right? So how does that language play out and how are we going to define that when the person making the behest is a legislator, for example? We are all subject to decisions by the legislature. Our agency is subject to decisions by the legislature. So how do we put some parameters around that so it's not so all encompassing? Because if that's true, I mean, if you read this expansively, in many cases, behest would never qualify for streamline, just because everybody by their nature is subject to a decision by a legislator, whether it's at the state level, the local level, your city council members. What are we really concerned with here, and how do we tighten this down I could see, for example, if you're talking about a situation where a developer has a specific item for approval before a city council or before the board of supervisors, I think that's the type of scenario where, if that developer has a pending question before a local elected official, and then they make a behest, that can at least optically raise some concerns. So if that's our concern, I think we need to draw this very narrowly. The way it's written now, I read it very broadly, or potentially could be read very broadly, and exclude just about everybody from Streamline at that point.
Well, I was anticipating that since there's a specific conflict of interest section for legislators, that the same terminology would be applied. So since that they have all their same rules about subject to decisions and non-general legislation, but I can easily clarify that.
Okay.
Because that's how the conflict of interest rules have been narrowed to identify decisions by the legislature.
So this bullet point is conceptual, and when it comes to drafting it, you draft it in a way that's more narrow to refer to non-general. For example, one way you would do that is through non-general legislation as the governmental decision.
Right. Yeah, that was the intention. I think I just did an automatic reference to it in my head as opposed to in the document. I'm like, everybody knows that. Sorry about that.
No,
I'll make it clear.
No, it's okay. It's helpful. This is why we're talking about it. It's why we do this. The second question, concern that I would express is, I know you mentioned that personal benefit, if the public official is getting a personal benefit, that would automatically be excluded. I have no qualms with that because we have a definition of personal benefit and there's a standard there. My concern was the second thing you said, which is the perceived personal benefit, because I think then that becomes a very challenging effort to define what is or is not a perceived personal benefit, and where do you draw the line. I'm comfortable if we have a reg that defines personal benefit, we have a standard to match it against. I think that makes sense. I think the perceived personal benefit, I'm a little uncomfortable with.
And that's a totally natural reaction to that, because that was put in for discussion, because one of the commissioners, Commissioner Hayward, was very in tune with things being held to a different standard when it comes to behested payments, including a perceived personal benefit. And so I put that in there to see where the commission falls on this as a whole, because obviously you can look at it two ways. You can look at it as too squishy of a standard to have in a document like this, but you can also look at it as it's an exclusion. So it can be one of those totality of the circumstances that enforcement then applies with some sort of discretion to determine this is too much or too close. We can't prove it, but it's too close to a personal benefit, so you're not eligible for Streamline. So that's why we put it in as a discussion item to see where the commission falls on it.
Yeah. Commissioner Cardenas, what do you think?
I don't know. Much of this area is anticipating particular fact patterns and trying to distinguish identities and behaviors and third party perception of what a particular fact pattern may suggest. I just don't know where I come on that. I have a somewhat separate question, but that doesn't need to happen right now.
All right. Well, I think at a minimum, I just think that's something to keep in mind. If you're going to present this to the full commission, I would suggest that we have some definition in mind of what the standard would be for a perceived personal benefit. I think, and just taking a step back, I do think it's important to remember that we should have some discretion in my view, for the enforcement chief to look at something, even if something qualifies for Streamline on its face. If there is conduct, if there's intentionality, if there's willfulness, If there are other factors at play there that in the discretion of the chief of enforcement suggest that this is something that's more appropriate for mainline, I think the enforcement chief needs to have that discretion. So I just, I want to make sure that what we're doing here, we're opening up Streamline. I think that's consistent with our goal to try and reduce mainline, make things more efficient, allow our enforcement staff to focus on the big public harm cases and spend our resources there while we're also developing a diversion program. I think big picture, this is consistent with where we want to go. I just think we need to be careful with some of the terms that we're using in fairness.
Well, Ms. West, if I may, to what extent does existing conflict of interest language help us in defining what a perceived personal benefit might be in this context?
I think we'd be looking at advice letters, but there's nothing in the current law that I'm aware of that is concerned about. I mean, maybe Dave can also chime in, but there's nothing in the current law about perceived personal benefit. So this is a new term that we're coining for these behested payment cases. Personal benefit is defined, and I can find that citation, but it's a new. We're charting new territory.
And so to some extent, one must understand something about the identity of the perceiver, right? So is this a reasonable person standard? The perceiver, a fact pattern which, in the view of a reasonable person, would inure to the benefit of the individual?
That could be one way to define it. It would be as an independent person looking at a set of facts as a reasonable person. That's the standard for probable cause. I mean, so it's used elsewhere. A person of ordinary prudence and caution, I think, is what the standard is.
Mr. Chair, if I might, I have a question.
Please.
In trying to imagine how this would actually apply and play out, sadly, there's in the morass that has been the City of Los Angeles City Council revelations of alleged impropriety and criminality. There are fact patterns that perhaps can be illuminating and instructive in this regard. And so my open question is this: the language, and I understand this is not regulatory language. That these are bullet points to engender thinking. Quote, the maker of the payment is a named party in or subject of a governmental decision before the behester or the behester's agency. Well, among the fact patterns in the City of Los Angeles, as I understand it, were behested payments that commenced prior to certain zoning and permitting approval items were actually before the since indicted members committee. But these were high dollar, high stakes development projects that were mature in their process through the city's building and zoning permitting apparatus, and were clearly about to come before the since indicted members committee. And in fact, they did come before the since indicted members committee. And the behested payments had been made before they arrived at the committee. So how might what we would do here apply to that kind of fact pattern? Because the people who are most adept and the people who are, if for no other reason, in possession of the greatest skills to be able to circumvent our best efforts. Those are the guys who know very well, no, man, you don't start your behested payments now. I mean, you don't wait to make your payment until your project comes before the guy's committee. No, man, you do that now, because we know it's going before the committee, right? So do it now. Show your good faith to the member, right? Early money is greener in this business, and you're going to avoid this higher level of scrutiny. Aren't you glad you met me, a clever lobbyist? And so how might we address that type of a situation, where the action, the governmental decision, is not quite yet before the government official?
Well, I think that there could be a timing element that can be placed into any of these criteria. So you could use something like, I don't know if you're familiar with Section 84308, but Section 84308 is the only section of the Act which it causes campaign contributions to cause you a conflict, so that you can't vote on certain things or you have to do certain disclosures. And that statute has a timing element, 3 months before, 3 months after, and certain disclosures made not only by the public official, but also the donor, contributor. And so you could do something similar to that for exclusions in this, but as to when other things become violations, this is just the tip of the iceberg. This is just talking about when it's excluded from the Streamline program. So this would be, the suggestion could be that the timing was, because we haven't actually limited this in timing, is that the action is named party in. We could definitely put in timing within 3 months, within 6 months of the action, any timing element like that. Because we have the freedom of, when creating what is qualifying for Streamline and what is qualifying for Mainline, the commission has the freedom of setting that policy.
Right, very helpful, thank you.
So I have a question. I'm going to kind of go back to the fact pattern that Commissioner Cardenas described, which to my way of thinking, what he described is not really a behested payment situation. It may have been couched that way by the actors for strategic reasons, but really the payments that were being made under those circumstances are for political purposes, which I think under the Act makes that more of a contribution. And if they were doing that to try and get beyond the contribution limits, then the violation before the commission wouldn't even be a behested payment violation. That would be a contribution limit violation, which would be under a separate part of separate eligibility, I should say, under Streamline. So
Which is probably why there's an indictment.
Which, probably, yeah, that's exactly right. But more, I think the thing to remember here is that is why it is so important that enforcement has the resources and the discretion to prosecute the cases in the way that actually meets what the violation really is. Because what Commissioner Cardenas described, that's not a behested payment problem. That's somebody who's calling it one thing, but in fact it's something else, and it should be prosecuted as such. I think when we're talking about Streamline and what we're trying to do with BEHES, Major Donor, and Streamline, what we're really talking about there is where somebody has filed a late behested payment report, or hasn't accurately filed a behested payment report, and that's what you see. That's what it, after investigation, really is. And the only question is, what's the better use of our resources? Do we put that through Streamline, or do we devote more substantial resources through Mainline? And this, in my mind, again, if that's what we're trying to do, if that's the point of including behest and major donor here, then in theory, at least, we should be opening up resources in enforcement to do the deep dive investigations to uncover where something really isn't a behest, for example, but it's an invasion of the contribution limits, or it is truly for personal benefit, which is a violation of the personal benefit rules. So again, I just think taking a step back and thinking holistically, the goal here is to take the low-lying violations and get them into streamline to free up resources in mainline to go after the intentional, willful conduct, such as what Commissioner Cardenas described.
Mm-hmm.
Does that make sense, Commissioner Cardenas, like what I just said to you?
Yes,
Do you agree with
yes, clearly, very, very good point. In the particular Los Angeles City fact pattern, there were contributions made at the behest, which were political contributions to the campaign of the sitting member, since indicted, spouse's election committee, so that she would succeed her since indicted husband. There were also payments made at the behest that were made to by the same parties, by the way, who ended up contributing to the spouse's election campaign, which were made to a nonprofit educational organization, which at the time either benefited the school that the spouse was working at, or benefited the foundation supporting the school, which foundation the spouse herself was at the time working at. So the way these guys play is they make contributions to whatever the government official wants them to, and that could be a campaign contribution, or it could be a seemingly innocuous contribution to a legitimate nonprofit, but it has the effect of inuring to the benefit financially and or politically of the government official.
No, I think it's important to keep that in mind. All right, Commissioner Cards, did you have anything else on the proposal to include behested payment reporting in Streamline and how we'll do it before we move on to to number 2?
Mr. Chair, if I might ask if someone could stir my recollection, how are we dealing with behests that are actually made not by a government official or a staff person in her office or otherwise under her control, but a lobbyist?
So are you referring to a behest by the lobbyist on behalf of an elected, or a behest by the lobbyist just in their own
a
capacity?
behest by a lobbyist made on behalf of the government official. That is the LA City fact pattern.
Either Mr. Bainbridge or Ms. West, would you care to? I think what would be helpful is how does the Act and our regs currently deal with that fact pattern? If you need some time, we can come back to that.
Well, it's an agency relationship, so it would be, I'm sure Karen Harrison's on here, who is our behested payment expert, but I don't think that it would be treated differently than any other agent of a public official. I think we touched on that at the last meeting about the responsibility goes back to the public official for the agent's work, just like in every other section of the Act.
Thank you very much.
All right, thank you, Commissioner Cardenas. All right, at this point, let's go ahead and move to the second point in your memo, Ms. West, about the criteria that we use. Why don't you go ahead and you go. population criteria.
Certainly. As I talked about in the memo at length in the presentation, under the 2015 streamline policy, the threshold was $25,000 per statement or report, regardless of your jurisdiction. And under the current streamline regs, even the largest jurisdictions have joined the increase to $100,000, but approximately 90% of the jurisdictions had their eligibility thresholds greatly reduced by the modification. And so in addition to this and the 24-hour reporting rules, we've actually decreased in the number of committees that have qualified for streamline, and 77% of our cases used to be qualified for streamline and processed through that program, and now 66% since the changes have gone into effect. So what we're really talking about here is, I don't know if anybody has 18360.1 in front of them, but when you get to the requirements for eligibility in the streamline program, oh, I tried to lick my finger again. Of course, I can't find it right off the top of my head. But anyway, it's page 5. Thank you, Dave. It starts at populations under 10,000 is what the current rules are, and $4,000 per statement or report is the threshold cap for that. And what we're proposing is that we actually take it up to the population for under 390,000, because what we have found is a lot of first-time filers, all of their activity is on one statement. So it's generally on one pre-election statement, and it's their entire campaign. And so they're excluded from streamline because their entire campaign was $4,000 or $8,700. And so these are the types of committees that the commission has expressed that they want to have first-time filers with small committees included into the streamline program. And what we have found is they've been excluded from the streamline program.
All right. Well, I mean, my reaction to that is that that's kind of taking things in the wrong direction for policy-wise, where we want to be. I think we want more cases to go into streamline when appropriate. Again, maintaining that safety valve where the chief of enforcement, if there's evidence of willfulness, intentionality, conspiracy to evade the act, has the ability to claw that back out of streamline and proceed as a mainline case. I think as long as we have that outlet, we should be trying to put as many cases through streamline as we can. So if a refinement of the population limits helps us accomplish that, that seems to make good policy sense to me. Commissioner Cardenas, what do you think?
I agree with everything you just said. Absolutely.
All right. So, Ms. West, when this comes to the commission, I think in draft form, you should be presenting it with those changes to the population limits. I mean, I think we're a ways away before this is coming before the commission, but when it does, I think it should include that.
When it eventually gets before the commission.
Correct. All right. Why don't you go ahead and move on to item 3? We already sort of touched on this about the diversion program, but just briefly what the concept is there.
Yeah, about every 5 to 10 years, the Enforcement Division puts forth a proposal for a diversion program to the commission, because we do educate a lot of first-time filers that are confused by the rules, and we really think that there should be a mechanism to where first-time filers that are ignorant of the rules can go to, I think one of the enforcement attorneys called it the traffic school for FPPC violations. And we do think that a program like that would be helpful, because some of these violations are they're not intentional, and we've determined that, and we've just determined that they acted as their own treasurer and they tried to work it out, or their friend was their treasurer. And we really would like to invest some resources into coming up into an education program, especially nowadays when electronic programs are so prevalent. It seems like now is the time. We're finally at a point in history where this is a viable option that's not $100 million, whereas 10 years ago when we last discussed it, it was probably an outrageous sum to try and come up with an education program. But I think now we're finally at a moment in time where there are so many training programs online that this could be one of those.
All right. I mean, again, from a policy perspective, I think this makes an incredible amount of sense. I wish we had, quite frankly, I wish, you know, you mentioned this has been something that's every 5 years or so, it keeps coming back to us. I mean, I feel like we should have done it, you know, 10 years ago, but I think now is a good time, as you mentioned, for technological reasons to actually pursue it. Commissioner Cardenas, what do you think about this?
Yeah, agreed. I mean, you know, it's as time provides staff with greater experience, my sense is that staff is correctly identifying opportunities to fine tune, and that strikes me as an enlightened way to go. I mean, it's one position may be, well, why can't we get it right? And the other position is, we'll never stop trying. And I commend staff for, you know, staying on top of things and identifying ways, given the way that this really is playing out, you know, in their real world experience, identifying ways to make this at the same time more efficient, but also more equitable.
Yeah, I think that's right. I mean, when I think about the diversion program, my hope is that it's particularly beneficial to folks who are first-time candidates, first-time participants in the political process, and that they see that, you know, they can do that. There's room for them to make the common mistakes that everybody makes without having to pay fines or be prosecuted in such a way that dissuades them from continuing to participate. Because I think that's the wrong message that we're sending. So I think this would be very helpful.
Great. With the disclaimer that we can't control the fines by filing officers.
Right. No, we're doing what we can.
They will still get there.
All right. So that brings us to item 4 then, regarding discretion.
Yeah, so what we have discovered in the year and a half since the Bright Line rules were instituted is that sometimes the rules are too strict, and they've really taken away a lot of discretion from the enforcement chief. Speaking about myself in the third person, not weird at all. If the first-time filer has amended their filings before the election, they won't be considered for warning letter or streamline if they've exceeded the population threshold, the 24-hour reporting. So the exclusions are so definite, there's no wiggle room. So yes, there is a little wiggle room in the criteria that says make sure that you consider intentional and all of those other things. And obviously we would also like that kind of expanded out to reasons you can be excluded from streamline. But really the main thrust here is the things that should be in streamline, that we're not being able to put enough weight on certain factors. Like, this isn't intentional behavior. This wasn't even really negligent behavior. They corrected, they did everything that they could, but yet they fall into one of these exclusions. So this is something I'm hoping the commission will consider as a good course of action for fair and equitable treatment, that we can weigh the factors differently and put emphasis on the things that the commission has found to be important.
Thank you, Ms. West. Commissioner Cardenas, what do you think?
Sounds terrific.
Yeah, I agree. I think it makes a lot of sense.
Well, that is all I have.
I do have a question about that. I mean, thinking about it in the reverse, so you have a case that qualifies on its face for streamline, but after further evaluation in the chief of enforcement judgment, it involves, let's say, willful conduct that shouldn't be included. Would that decision and that description of something as being intentionally for a reason removed from streamline and brought up to mainline, is that something that you would envision the chief of enforcement reporting to the full commission?
I think that it does come up because, like, for instance, every mainline case that's presented to the commission, the attorneys have to tell me why it didn't qualify for streamline. And I consider that to be public information that I can answer to the commission.
Okay.
And so half of the attorneys put it into their exhibits and the other half report it to me before the commission meeting. And that's one of the things that I'm always prepared to answer of why this case did not qualify for streamline.
I do think, from my standpoint, I think it would be, and if we include something in the regs, maybe that'd be helpful, just to make it very clear that the chief enforcement should be communicating those decisions to the commission, so the commission isn't surprised to learn from somebody else that that type of a decision was made. I think that's important for internal transparency as well.
That's something we could look into adding to the exhibit.
Okay, I think that'd be helpful.
Oh, I'm sorry, these stipulations. It's all one document now.
All right.
Showing my age.
Commissioner Cardenas, did you have any further questions or comments on the streamline
I actually missed it.
regs and discussion we just had before we open it up to public comment?
I'm just wondering when we're going to get to the 44 slide presentation.
We're going to do that in about 30 minutes. It's there for you to peruse at your leisure.
Oh, we're not going to go over it.
No, I think we've seen it before. Chief Enforcement West presented that to us a couple meetings back, but you have another copy here so that you can continue to relive the experience as you see fit.
Oh, if this was in July as dated, then I believe that was before my addition to this committee. I have a question about slide 26.
Okay, it was actually at the commission meeting.
Oh, it was.
Well, why don't we just go to slide 26 so we can get Commissioner Cardenas, let him ask his question. Is this exclusion and eligibility dash record keeping, Commissioner Cardenas?
Yes.
Okay.
The last column, Ms. West? Do you see the last column?
Page 26. Last column.
Okay, go ahead.
Is there a period missing, or was there more that you're going to add, or at the end?
Yes, there is a period missing.
Okay. Mr. Chair, I'll let the record reflect. I go through this stuff, okay?
Noted, as evidenced earlier by pointing out the hanging sentence that began with however and had nothing after that.
Yeah, and that wasn't even one of our staff documents. But on a more serious or a less inane note, with respect to the very last slide, there's a question that's raised that I honestly don't remember us perusing, and that is with respect to a pre-notice. Should the percentage added to the penalty increase based on how early the respondent participates in settlement? So the suggestion here is to in a sense, incentivize the respondent financially to get on with the settlement?
Yes, so as in the penalty section in point 2, what we had before was that the percentage would go up as we went further into the process. So like for late lobbying reports, it would be $200 plus 1% of the payment for the first attempt, and then $400 plus 2%. And so what we've found is that this isn't necessarily incentivizing anyone, but it's causing the streamline penalties to progress rather quickly as they go through the process. And so we were proposing to make them all stay at 1% and not have them be progressive. But that's what we wanted to get the thoughts of the commission on.
Huh. Interesting. So it's not affecting respondents' settlement timing decision making, apparently.
It hasn't incentivized pro pers.
Oh, yeah, okay. All right, that's it. Thank you, Mr. Chair.
Well, hold on, now I'm upset. So that was a very careful answer. It hasn't incentivized pro per. So what proportion of the cases coming through Streamline are pro per versus represented?
The majority of the cases in Streamline are pro per.
Okay, I think that's important.
I'd say you could even say upwards of 85%.
All right, so then for most of the cases that you're seeing in your experience that are going through Streamline, the progressive penalties are not effective in the way that we anticipated at the time these were adopted.
Right, and so since a lot of cases settle after PC, after an accusation has been issued, it seems like once you get personally served an accusation, you realize this isn't going away, and they then want to settle, but then by then you're at, a higher penalty plus a higher percentage, and so the incentive to settle, it has mostly been taken away at that point, because the best offer is probably less than if you roll the dice and go to a hearing. And so enforcement wanted a little more wiggle room in order to still be able to offer a reasonable settlement through Streamline.
All right, that's helpful to understand. So I think this is another area, the other areas we talked about today, that when you put pen to paper and are coming back to the commission with the regs for further discussion, that it incorporates that feedback you just received. All right, Commissioner Cardenas, did you have anything further before we go to public comment?
No, this has been a very helpful discussion. Thank you.
All right, thank you. All right, let's go ahead and go to the phones for public comment on item 4. This is the regulations concerning Streamline and the warning letter programs.
Hello, can you hear me?
Yes.
Hi, good morning, Chair Matich and Commissioner Cardenas and everybody else. This is Trent Lang, President and Executive Director of the California Clean Money Campaign. My apologies for having just noticed these issues I'm about to raise. There are a number of them. But first, I'd like to thank the staff and commission for suggesting these kinds of changes. Many of them seem like significant improvements. But that said, as sponsor of the California Disclose Act, we do have a number of concerns, especially regarding issues that directly impact the Disclose Act. The biggest and I think the most important of all is that the new Tier 2 for advertising and mass mailers looks like it would allow committees to be streamlined even if their ads fail to list 2 top contributors of $50,000 or more. I'm sure it's not the intent of the staff, but we're very concerned that that appears that would go very much against the intent of the Disclose Act, because the whole intent of the Disclose Act was to show the top contributors, and the streamlining penalties are extremely minimal and could be just viewed as a slap on the wrist. So, and while I was looking at that, we noticed that there's actually a similar, because the rule there is, I don't know if I should just give the general comments, you figure out the rules or what, but there's a similar problem with the exclusion, even in Tier 1, where it says that the advertisement on or mass mailing contains, 2 or more missing or incorrect disclosures or display requirements in the disclosure, and 1 or more of the missing or incorrect disclosures is 1, the paid for by the committee requirement, 2, top contributor information, and then a couple other different things. So even the existing Tier 1 style looks like it would allow, if somebody had a perfectly formatted ad that purposely left out that some major corporation or somebody else that gave millions of dollars to the campaign left that out as a top contributor, that would still allow it to be streamlined and have the therefore very minimal donations. That's our reading of that. If that's incorrect, we'd love to know.
Well, one thing, Mr. Lang, before you go further, you used the term purposely left off. I just want to remind you that under the Streamline rules, if there's purposeful evasion, purposeful activity, intent, willfulness, those are exclusions writ large from Streamline.
Good point. First of all, staff may not always be able to prove whether or not it's purposeful. And second of all, any top contributors are by definition of $50,000 or more. And if they're doing advertisements, they're spending significant amount of money. So this is not the sort of thing that small contributor committees that are doing things for the first time are going to be having mistakes on. So any leaving out of a top contributor that should be appearing on ads could directly impact elections by not showing voters on those ads. In many cases, millions of dollars worth of ads, even if it wasn't purposeful. And that just doesn't seem like that should be allowed to be streamlined. In fact, what we would suggest and request is that any missing or incorrect top contributor should not be eligible for streamlining or have a much higher penalty structure.
All right. Mr. Lang, we do have time limits for public comments. I'll go ahead and give you another couple seconds just to conclude your thoughts. We're at this is not even before the commission at this point. It's not up in October, so I think you have multiple additional opportunities to provide further comment, including in writing if you so chose.
Okay, well, I guess I'll have to do that because there's a kind of a significant list of these, both regarding the Disclose Act disclosures and also some of the things related to it, like the late reporting requirements. So thank you for your consideration. We will definitely send in a full letter detailing this and hope you will consider it, and look forward to any discussion to follow.
All right, great. Thank you very much, Mr. Lang. I appreciate it. Oh, sorry, Ms. West, did you have some?
Hi, Mr. Lang. This is Galena West, and you have my email address, so feel free to reach out to me. I would make a comment that the section above, the one you're looking at in Tier 2, does exclude from a streamlined program the Tier 1 if the violation is likely to result in confusion regarding the top contributor. Basically, why top contributor is included in the other parts is when the top contributor information is slightly incorrect. But I'd be happy to talk to you about that. And like I said, you have my email address, so we can set up a time.
Great. All right. Look forward to it. Thank you.
All right.
Thank you all.
Thank you. Do we have additional public comment on the telephone for item number 4? Hearing none. Do we have any digital public comment on item 4? Seeing none. Well, thank you very much, Ms. West, Mr. Bainbridge, Commissioner Cardenas. I think it's been a helpful discussion. Thank you to Mr. Lang, as always, for his comments on these. And so we'll continue to refine these and bring them back to the commission and to the committee at a future date. So we'll go ahead and move on at this time to item number 5. This is our Commissioner Code of Conduct. We committed some time ago to revising that. And I believe that we have, we have Commission Counsel Mr. Cornwall with us. I see you on video. Good morning, Mr. Cornwall.
Good morning, Chair Matich and Commissioner Cardenas. Today, I'm presenting for discussion and direction staff's draft of a Commissioner Code of Conduct that would update and replace the Commissioner Manual. Just as a quick recap, this process began in October of last year when, upon the Commission's request, staff presented a review of chapters 3 and 4 of the Commissioner Manual and identified that the document contained several ambiguities with respect to the information it conveyed. In some instances, it was unclear whether information should be considered an express statutory requirement, an adopted policy, a best practices suggestion, a legal interpretation, or merely informational. In the following months, staff responded to requested revisions and identified other areas for improvement and clarification, and ultimately began working on this updated Commissioner Code of Conduct that would resolve the aforementioned ambiguities. So with that in mind, staff has drafted this Code of Conduct with the goal of clearly distinguishing express legal requirements, commission policies, interpretations, and best practices. Just walking quickly through the document, the first section of the Code of Conduct includes a portion of the Commission's governance policy, which staff would also provide a complete copy of to the Commissioners as a standalone document. This is the section pertaining specifically to Commissioner conduct and has been updated to include language identified by Commissioner Cardenas that would require commissioners to, at all times, meet high ethical standards that exceed legal minimums. The second section pertains to political activities. In the Commissioner Manual, both chapters 3 and 4 contain sections on political activities. And it was again unclear whether the information was to be considered commission policy or an interpretation of 83105, section 83105 of the Act. Accordingly, staff has updated the section to more clearly lay out what section 83105 expressly prohibits and what the commission has interpreted section 83105 to prohibit, as well as best practices recommended by legal staff. The following sections on statements of economic interest, gifts, honorarium and travel, conflicts of interest, and ethics, those haven't been significantly modified from the Commissioner Manual other than updating them for clarification. For instance, the gift section of the Commissioner Manual, it was unclear again whether it was commission policy when in fact it was what was expressly prohibited under the Act, or additional information. For instance, the Commissioner Manual didn't have much information on the Act's conflict of interest provisions, so we've added those as well. The section on ex parte communications in the context of enforcement proceedings has also been significantly revised. Here in the Commissioner Manual, the information on ex parte communications, it wasn't clear whether it was supposed to be read as a legal requirement or you know, one reasonable interpretation of case law. Accordingly, staff has updated the section to more clearly inform commissioners of what's expressly required by incorporating the language of the relevant APA statutes, just sort of tweaking them to more specifically address the context of, you know, how enforcement proceedings occur within the FPPC. And then finally, the additional commission policy section, it's generally comprised of policies that the commission previously requested and reviewed the language of at the February 2020 commission meeting and approved for inclusion in the Code of Conduct. So that's the sort of the gist of what staff has prepared, but if either of you have any questions, I'd be happy to answer them.
Thank you, Mr. Cornwall. And thank you, Commissioner Cardenas, for all of your work with staff on this. Did you have any edits or comments with the document that staff has prepared for us?
Mr. Chair, thank you very much. I do. Let me state how proud I am of this document and what a privilege it has been for me, Mr. Chair, to simply bask in the light of the tremendous work done by our staff in this effort, led by Mr. Kevin Cornwall. Kevin, you've done a remarkable job of not only faithfully capturing what the commission was expressing would be the hope coming out of this document, but you've even added, I think, to what I suggested at the time, must end up being an aspirational document, a document that guides our behavior consistent with the better angels of our nature. And so I feel personally indebted to you, Kevin. I think you've done a terrific job.
Thank you.
I do have a couple of edits, and I apologize, Kevin, that these have only more recently occurred to me, even though we've been working on this for almost a year. But Kevin, with respect to Section 2, political activities under 83105,
Right.
the last bullet point there. As as we know, a commissioner cannot seek election to any public office during the time of the commissioner's appointed term. And what this means, to parse it down and get to real world application, is that, as you point out, the prohibition applies for the entire term of the appointment. Kevin, I'm just wondering if we might be a little bit more specific, because what it means is that even if a commissioner were to leave the commission before the expiration of her term, and then post vacating of the commission position, seeks election before the term that she didn't fulfill has itself expired, she is still in violation of 83-105. And I had occasion in the past year to really dwell on this, but only more recently seeing this language. I'm just wondering, Kevin, if perhaps we can't be a little bit more explanatory and maybe add language at the end there before the close paren. Even if a commissioner has vacated his commission office prior to the expiration of her term, just so that in the future, a commissioner understands that it was always the intent of the legislature in the 1980s when this amendment was made, when a certain commissioner left the commission before the expiration of his appointed term expired, and then ran for state office. I'm just wondering if we could just make that a little more clear.
Yeah, we can edit the language to more, expressly convey what you're talking about, which, yeah, that's an, accurate reading of 83-105. And if you'd like, we can add to the, best practices as recommended by legal division. I believe there's, and, it's been a while since I read this case, so I would want to go back and reread it, but I believe there's a Supreme Court case sort of upholding a similar statute with respect to, I think, judges in Texas. So, so I can go back and include a citation to that case if I'm remembering the holding correctly. But
yeah,
yes,
I believe you are, Kevin, and also whenever the law was passed to so amend 83-105. In response to a commissioner, you'll recall, who left the commission in whatever it was, 85, and then in 86 ran for a statewide office. And as I recall, the FPPC at the time had initiated, under said commissioner's tenure, an investigation of the sitting statewide officer whom the departed commissioner then ran against. And so if I remember correctly, it was, and I remember because the gentleman was my state senator at the time. It was State Senator Joseph Montoya, as it turns out, who sponsored the bill that ended up effectuating, I think, appropriately this law. But yeah, whatever language you can add that just makes it more clear to incoming commissioners, just beware, you can't run for anything during your term, even if you leave before the expiration of your term. And then I have one other comment elsewhere in the document, if I can. Mr. Cornwall, section 6, dealing with conflicts of interest.
Yeah.
You'll recall about 3 years ago, a different commission, different chair. Only 2 of the current 4 commissioners were on the commission at the time. The tone and tenure was very different, but in the collective wisdom of the commission, we took a vote that changed how it is that commissioners are quote unquote reimbursed for their expenses, but also how commissioners are, and I'll just use the term compensated for their service on the commission. And I remember stating at the time that I thought it was a mistake for the commission to vote to do that. We obviously did at the time vote to do that because it has had the effect of frankly increasing the amount of money, from what I can tell, that commissioners receive for the privilege of serving in this office, and having given it more thought and being profoundly disheartened about the commission's vote at the time, and disheartened at my own vote at the time. I wonder, Mr. Chair, if we can ask staff to give some thought outside of the parameters of this document, but give some thought to another mechanism, perhaps another body within or without the FPPC structure itself that would consider any changes to the way that commissioners are reimbursed and or compensated for the privilege of serving on this body. We should never have taken that vote, and future commissions must never vote on effectively dollars coming to them. And so whether it's a body of the executive director and chief legal counsel and any commissioner who may not be affected by the vote, theoretically, you could have a situation, right, where a particular commission might not be affected by the vote, or in advance simply, simply opts out of the opportunity to receive any heightened payments to herself by virtue of the vote, which or some mechanism where there is more an objective, by its composition, an objective deliberation on the matter of whether or not a commissioner's compensation / reimbursement should be adjusted. I think it was a conflict of interest at the time, and it would be a conflict of interest today. Thank you, Mr. Chair. And again, Mr. Cornwell, thank you very much for your work.
Thank you.
All right. Thank you, Commissioner Cardenas. I think with respect to the issue you just raised, it would be something that I think would be appropriate for us to agendize for discussion at the next law and policy meeting. I'm reluctant to get too far in the weeds on it today because it hasn't been properly agendized. But I do think if what you're interested in is hearing ideas or concepts from staff about different ways of approaching the issue of commissioner compensation, where we wouldn't be putting commissioners in a position to vote on their own compensation, then I imagine there's a couple different permutations on that staff might be able to present to us. We can give some feedback on, and then at the committee level, and then bring that back to the full commission, because I share your concern. I feel like as the chair, I guess I'm sort of lucky in a way that my salary is just set by statute. I don't get a say at all in that. So I do think it's something that's worth bringing back to the committee. So Mr. Bainbridge, I'm sort of put you on the spot, but I mean, if we wanted to at least have a preliminary discussion on concepts next month at Law and Policy, do you think is that doable, or do you think we need to push it to December? I would hope that we can get to it this year.
Yeah, I think for discussion purposes, we can start thinking about ideas and have something in the next month.
Okay. So I think to me, that seems to make the most sense. Let's have that on our agenda in November, and let's address it at that point, if that works with you, Commissioner Cardenas.
Mr. Chair, that was precisely my hope in raising the issue. Thank you so much.
Thank you. I did have one, going back to your first comment. I think you're absolutely right that we should make it expressly stated in the last bullet point under political activities that in the prohibition against seeking election includes even when you resign. The only comment I would offer is I think this may be a circumstance where it might be useful to, at the conclusion of that bullet point as modified, that you add a footnote, and it's worth 3-4 sentences describing that 83-105 was amended specifically in response to a circumstance, as Commissioner Cardenas described, where somebody did try to resign and then run for office. So there's absolutely no doubt that that is what the legislature intended, and those are the ground rules that everybody signs up and abides by. So I just think having that additional description there, it may in the future avoid the question coming back to us, why do we interpret it that way? Well, read the footnote, that's why. That's the point of it.
No problem.
All right. Otherwise, with the changes that we've just described, Commissioner Cardenas, I believe that we should recommend adoption by the full commission of this code of conduct at the next, obviously not next week. Or I'm sorry, it is. Now I'm getting confused. This is on the October agenda, so pardon me. So I would like us to. I'd like to move that we recommend adoption at the October commission meeting with the edits we just discussed.
By all means, I second.
All right. Is there any public comment on item 5 before we proceed to a vote? Hearing and seeing none. Ms. Linker, would you call the roll?
Commissioner Cardenas?
Yes.
Chair Matich?
Aye.
The motion passes.
Excellent. And again, thank you, Mr. Cornwall. Outstanding job, and thank you, Commissioner Cardenas, for your work on this too. I think this is it was an important thing for us to do, and this is a great product. So thank you both.
Thank you, Mr. Chair, and once again, but not for the last time, Kevin, thank you very much.
Thank you.
All right, working our way down the agenda here. We are now on item number 6. Commissioner Cardenas, do you want a 5-minute break, or are you good to keep going?
Either way is fine with me, sir.
Okay, let's keep plugging ahead here. So item number 6, this is our continuing item on behested payments. We have Senior Commission Counsel Karen Harrison here with us remotely. Good morning, good afternoon, Ms. Harrison.
Good almost noon.
Yes.
So this is a part of our continuing discussion on behested payment reporting, and we're specifically talking today about e-filing and how the Form 803 is filed with the Commission. We provided a summary of this in a memo that was presented to the committee. So just in sum, we will be going over that briefly right now, identifying some of the issues and our proposal for a legislative change to address those issues. So as set out in our memo, essentially under the statute, Form 803, behested payments reports, is to be filed with the elected officer or PUC member's agency. The agency is then responsible for providing a copy within 30 days. If it's at the local level for a local official with their local filing official, and if it's at the state level, that agency would provide the copy to the commission. In addition, for state officials only, the commission allows a Form 803 to be emailed directly to the commission, or it can be e-filed through an e-filing system that we have. This e-filing system, electronic filing system, that alone allows state officials to file reports electronically directly with the FPPC, and it's similar to a Form 700 filing system. As a part of that e-filing system, the FPPC website has a web page where members of the public can search for behested payments and obtain data about the behested payments that are reported. It can be searched by official or it can be searched by payee. And this database is populated automatically when a report is filed electronically. And currently, when you look up that database filed report by the official or by the payee, it doesn't show all the fields that are filled out on a Form 803. It's not the Form 803 itself, it's a crunched version. Now, as to hard copies, our education staff has to manually input the Form 803 data into the electronic system. The PDF versions of hard copy are available on request. They're not available on our website. So the legal division has discussed the filing system with the local ethics agencies, Senate and Assembly ethics attorneys, as well as our own staff that handles these submitted forms and our IT department. The current system causes some unnecessary effort in filing. It causes effort in acknowledging the filing and then again in making the data available to the public. There's some inconsistencies in how the different filings are processed, and each method has its own set of minor issues that need to be addressed. So to move forward and address these identified issues, the legal division is recommending a legislative change to amend section 84224 to require state officials to file the behest of payment reports directly with the FPPC using the electronic system, which would be updated to address some of the issues I talked about, and also to allow local agencies to treat e-filings at the local level as original filings, as a wet signature. This has been an issue for some of the local ethics agencies. This proposed legislative change would address the filing issues. It'd be an efficient, modern filing system. It would better serve filers, our own staff. The agencies would no longer be the middleman, and the data would be more readily available to the public. At this time, I'll take any questions that you have, however deep we want to dive into the Form 803 filing system.
Well, I think, let me begin by saying I appreciate you educating us on what the current process is. It wasn't until pretty recently that I think I appreciated the fact that we had staff who were working very hard and spending, combined over 15 hours a week, essentially doing data entry and transposing data from a hard copy onto our website, which I think could be made more efficient by having a statewide electronic filing system, as you're suggesting. We suggest legislatively, but also the concern is that in that process there are errors that are made, not intentional, obviously, but it happens sometimes, and I think we want to avoid that too if we're putting that information out for public consumption. So from my standpoint, I think your suggestions, staff suggestions that we pursue legislation here certainly makes sense from an efficiency and a policy standpoint. It sounds like, at least preliminarily, stakeholder input has been positive on this potential legislative change, which is also good to hear. So, Commissioner Cardenas, did you have thoughts on that?
I think it sounds terrific. I'm a big believer in modern document management systems for our staff to have to be transposing, replicating data from one form to another. People are much too talented to have to be doing that.
Right. Okay. Well, excellent. Mr. Bainbridge, as a matter of process here, at our committee, what I would like is to provide the necessary input to our legislative council then to include this proposal on our legislative package. So Commissioner Cardenas and I formally vote to recommend that to the full commission then at this point?
Yeah, I think that'd be a good idea. Since the commission has already adopted some legislative priorities, we should probably do this one through the same manner. So it'd be helpful to have the recommendation now.
Okay. All right, then I would move that we recommend to the full commission to amend our legislative package for 2021 to include the legislation that Senior Counsel Harrison just described, which would allow a mandate electronic filing of the 803s for state officers directly with the FPC.
Second.
Excellent. Ms. Linker?
Commissioner Cardenas?
Yes.
Chair Matich?
Aye.
The motion passes.
Excellent. All right, Ms. Harrison, I notice you have two other items in your memo you want to discuss with us today.
I think you might be referring to the user identification and the e-filing as the original. Is that what you're referring to?
Correct. I just wasn't sure if there was more on either of those items that you wanted to discuss with us today.
Just to comment that those are two particular items we wanted to call out that need to be addressed during the process, and we certainly could address it with this legislative change proposal.
Okay. Well, you anticipated my second question, which is were user authentication and e-filing as original regulatory or statutory? But it sounds like in your mind we could accomplish these through statute, the statutory change.
That's my understanding.
Okay. Very good. Commissioner Cardenas, did you have any additional questions or comments for Ms. Harrison at this point?
Sorry. No, I do not. Thank you.
All right. All right, Ms. Harrison. Well, did you have anything additional that you'd like to discuss with Commissioner Cardenas and I today on this?
Not at this time.
All right. Do we have any public comment on item number 6? Hearing and seeing none. Thank you, Ms. Harrison, as always, for your continuing work on this. Appreciate it. All right, we'll go ahead and move at this time to item number 7, our legislative update with our legislative counsel, Ms. Nakano. Good morning, or sorry, good afternoon.
Good afternoon, Chair Matich and Commissioner Cardenas. I have just a quick update on AB 2151. The bill was signed by the governor on September 28th.
Excellent.
And that's all I've
right.
got.
All right. With respect to the items in our proposed legislative package for 2021, I take it that you're reviewing language and starting conversations with folks on that. Is that correct?
Absolutely. We're in the process of researching and developing language for those proposals and have begun to reach out to some legislative staff about possibly authoring next year.
Excellent. Glad to hear it. Thank you. Commissioner Cardenas, anything for Ms. Nakano?
Ms. Nakano, good afternoon. Is there any indication of when the legislature may resume its regular and more complete legislative schedule?
At the moment, the legislature is set to reconvene on January 4th, but of course we don't know if COVID might change that. But at this point, January 4th is the day that they will are scheduled to reconvene.
Thank you.
All right. Well, any public comment on item 7? Hearing and seeing none. Thank you, Ms. Nakano. Appreciate it. And that brings us to our final item, our discussion of items for our November 2020 committee meeting. By my count, we have 4 items that I would think that we would want to hear. The first is the streamline process regs that we just heard. I think it would make sense to continue to receive and discuss feedback on those for staff's benefit and for the benefit of the public. The second, having a continuing discussion on vested payments. Perhaps we might even, hopefully by that point, have maybe proposed language on the e-filing of the Form 803 by state officials, so we can see that. The third item would be the options and concepts for commissioner reimbursement, pursuant to the conversation and point that Commissioner Cardenas raised earlier. And then the final item would be a legislative update from Ms. Nakano. Commissioner Cardenas, do those work for you? Do you have anything additional that you want to add?
I have nothing additional. I think that would make for quite a scintillating meeting.
All right, that's what I aim for. scintillating. All right, at this point, Commissioner Cardenas, did you have anything further that you wanted to discuss today before we adjourn?
No. No, I don't. I may have a more general question, which about basically our staff's. If staff is seeing anything, sensing anything in particular with respect to the November election, perhaps there can be some kind of a, I know it's been agendized, but some kind of an update or a report at the October meeting.
Well, I think, I mean, the first thing that comes to mind that I would imagine we would receive an update from Ms. West about is the Ad Watch program and how we're receiving complaints through Ad Watch, and any other major developments related to the election. I would anticipate we'd receive an update on that. Is that accurate, Ms. West? Is there something further or in addition to that that you had in mind, Commissioner Cardenas?
No, sir, no.
All right, well, at this time, would you care to make a motion to adjourn?
Mr. Chair, I move to adjourn.
And I second. Ms. Linker?
Commissioner Cardenas?
Yes.
Chair Matich?
Aye.
The motion passes.
Excellent. Thank you, Commissioner Cardenas. Appreciate it. Look forward to seeing you at the commission meeting.
Thank you, Mr. Chair. I look forward to it also. Please stay safe, everybody.